Senator Thune and the other senators ask the counsel for the president. On March 6, 2019, Speaker Nancy Pelosi said, quote, "Impeachment is so divisive to the country that unless there's something so compelling and overwhelming and bipartisan, I don't think we should go down that path because it divides the country," end quote. Alexander Hamilton also warned in Federalist 65 against the, quote, "persecution of an intemperate or designing majority in the House of Representatives with respect to impeachment." In evaluating the case against the president, should the Senate take into account the partisan nature of the impeachment proceedings in the House?
Absolutely, you should take that into account. That's dispositive. That should end it. Based on the statements that we heard the last time from our friends on the Democratic side, that's a reason why you shouldn't have an impeachment. Speaker Pelosi was right when she said that. Unfortunately, she didn't follow her own advice. We've never been in a situation where we have the impeachment of a president in an election year with the goal of removing the president from the ballot. As I've said before, that is the most massive election interference we've ever witnessed. It's domestic election interference. It's political election interference, and it's wrong. They don't talk about the horrible consequences to our country of doing that, but they would be terrible. They would tear us apart for generations, and the American people wouldn't accept it. Let me address in that context the importance of the vote for their inquiry, which also had bipartisan opposition. Now, they said, well, we were fine when Speaker Pelosi announced it. We didn't need a vote. The subpoenas were authorized. Then why did they have a vote? They had a vote because they understood they had a big problem that they needed to fix. But what's more important about the vote than the procedural issue? The important thing about the vote is that if you're going to start an impeachment investigation, particularly in an election year, there needs to be political accountability to the American people. You can't just go have a press conference. If you're going to say that the votes of the American people need to be disallowed, that all of the ballots need to be torn up, then at the very least, you need to be accountable to your home district for that decision. And now they are. And now they are. And if the American people decide, if they're allowed to vote, if the American people decide that they don't like what's happened here, that they don't like the constitutional violations that have happened, that they don't like the attack on a successful president for purely partisan political purposes, then they can do something about it, and they can throw them out. That's why a vote's important. But we should never even consider removing the name of a president from the ballot on a purely partisan basis in an election year. Important? I'll say it's important. For that reason alone, and for the interest of uniting our country, it must be rejected.
Senator Murkowski asks counsel for the president. You explained that Ambassador Sondland and Senator Johnson both said the president explicitly denied that he was looking for a quid pro quo with Ukraine. The reporting on Ambassador Bolton's book suggests the president told Bolton directly that the aid would not be released until Ukraine announced the investigations the president desired. This dispute about material facts weighs in favor of calling additional witnesses with direct knowledge. Why should this body not call Ambassador Bolton?
I think the primary consideration here is to understand that the House could have pursued Ambassador Bolton. The House considered whether or not they would try to have him come testify and subpoena him. They chose not to subpoena him. And this all goes back to the most important consideration, I think, that this chamber has before it in some ways, especially on this threshold issue of whether there should be witnesses or not, has to do with the precedent that's established here for what kind of impeachment proceeding this body will accept from now going forward. Because whatever is accepted in this case becomes the new normal for every impeachment proceeding in the future. And it will do grave damage to this body as an institution to say that the proceedings in the House don't have to really be complete. You don't have to subpoena the witnesses that you think are necessary to prove your case. You don't really have to put it all together before you bring the package here. When you're impeaching the President of the United States, the gravest impeachment that they could possibly consider, you don't have to do all of that work before you get to this institution. Instead, when you come to this chamber, it can be kind of half-baked, not finished. We need other witnesses, and we want this chamber to do the investigation that wasn't done in the House of Representatives. And then this chamber will have to be issuing the subpoenas and dealing with that. And that's not the way that this chamber should allow impeachments to be presented to it. And we've heard there was some exchange the other day about, well, there were a lot of witnesses in the Judge Porcius impeachment, and this chamber was able to handle that. It's very different in the impeachment of a judge, which is being handled by a committee. My understanding is that under Rule 11 of the Senate procedures, there was a committee receiving that evidence. But in a presidential impeachment, there's not going to just be a committee. It's the entire chamber that is going to have to be sitting as a court of impeachment, and that will affect the business of the chamber. And so I think the idea that something comes out because someone makes an assertion in a book, allegedly, it's only an alleged, it's simply alleged now that the manuscript says that. Ambassador Bolton hasn't come out to verify that, to my knowledge. That then we should start having this chamber call new witnesses and establish the new normal for impeachment proceedings as being that there doesn't have to be a complete investigation in the House. I think that's very damaging for the future of this institution.
A question from Senator Moran, Crapo, and Risch reads as follows. Impeachment for the counsel for the president. Impeachment and removal are dramatic and consequential responses to presidential conduct, especially in an election year with a highly divided citizenry. Yet checks and balances is an important constitutional principle. Does the Congress have other means, such as appropriations, confirmations, and oversight hearings, less damaging to our nation?
And yes, Congress has a lot of incremental steps, a lot of means short of impeachment to address friction or conflicts with the executive branch. And that was a point that I was making a moment ago with respect to what the Department of Justice had said in litigation today, where the absolute immunity for senior advisors, actually I think it's a different issue in that case, I beg your pardon, but in any event, there's a dispute in that case about information request. And the point that DOJ was making there is the Constitution requires incremental steps where there's friction between the branches. As I mentioned the other day, friction between the branches and between Congress and the executive on information requests in particular is part of the constitutional design. It's been with us since the first administration. George Washington denied requests from Congress for information about the negotiation of the Jay Treaty. And so from the very beginning, there has been this friction leading to jockeying for position and accommodations and confrontation and leading to ways of working things out when Congress demands information from the executive and the executive asserts to protect the institutional authorities of the executive branch, the sphere where the executive can be able to keep information confidential. But the first step in response to that should be the accommodations process. And the courts have described that as constitutionally mandated, as something that actually furthers the constitutional scheme to have the branches negotiate and try to come to an arrangement that addresses the legitimate needs of both branches of the government. Part of that accommodations process, as the confrontation continues, can involve Congress exercising the levers of authority that it has under Article 1 to try to put pressure on the executive. So, for example, appropriations, not funding the policy priorities of a particular administration, or cutting funding on some policy priorities, or legislation, not passing legislation that the president favors, or passing other legislation that the president doesn't favor. Or the Senate has the power not to approve nominees. And as I'm sure many of you well know, holding up nominees in committee can be effective in some points in putting pressure on an administration to get particular policies kicked loose, things accomplished in a particular department or agency. All of these elements of the interplay of the branches of government, that's part of the constitutional design. But impeachment is the very last resort for the very most serious conflict where there is no other way to resolve it. So there are all of these multiple intermediate steps, and they all should be used. They all should be exercised in an incremental fashion. And that's exactly what didn't happen in this case. There was no attempt at the accommodations. There was no attempt even to respond to the legal issues, the legal defects that the counsel for the president and the departments and agencies pointed out in each of the subpoenas that were issued by the House committees. And even the issue of agency counsel, there was no attempt to try to negotiate on that. And that's really something that in the past, even last April, with the House Committee on Oversight and Government Reform with Chairman Cummings, there was a dispute about that. And we wouldn't allow a witness to go without agency counsel. And then we had a meeting with Chairman Cummings, and it got worked out. And it was turned into a transcribed interview, I think, and agency counsel was permitted to be there. But the committee got the interview, they got to talk to the person, and they got the information they wanted. But the executive branch got to have agency counsel there to protect executive branch interests. And that's the way it's supposed to work. But there was no attempt at anything like that from the House in this case.
The question from Senator Shelby is for the counsel for the president. Though not charged in the articles of impeachment, House managers and others have stated the president's actions constituted criminal bribery. Can this claim be reconciled with the Supreme Court's unanimous decision in McDonnell versus United States?
The answer is no, it can't be reconciled with the McDonnell case. Let me make a couple of points in my answer. The first is, of course, because there is no bribery or extortion charged in the articles of impeachment, the managers can't rely on that now to try to establish their case. I pointed out yesterday, I believe, that that is a due process violation of the most fundamental sort, to have a charging document and leave out certain charges in the charging document, then come to trial and say, well, it's not in the indictment, it's not in the charge, but actually what we've shown you is he did something else wrong. It was this crime. As the House managers well know, that would result in an automatic mistrial in any actual trial in a court in this country. So that's the initial problem with trying to go there on bribery or something else. Then, as the senator's question raises, the McDonnell case made clear that simply arranging a meeting for someone, simply setting up a meeting with other government officials, couldn't be treated as the thing of value in an exchange under the bribery statute. And it pointed out particularly in terms of government officials who all the time are asked by their constituents to introduce them to someone else in the government, to arrange a meeting, that is not an official act. It's not an official policy decision, an action that is determining some government policy. It's simply allowing someone to have a meeting to then talk about something. If that's the nature of the meeting, that can't be the thing of value that is being exchanged and can't support a charge of bribery. So they can't raise it because it's not in the articles of impeachment. If they had wanted to charge that, they had to charge it in the articles of impeachment. They can't come here now and try a different case from the one they framed in the charging document that they had complete control over drafting. Even if they did, they can't make out the claim with respect to the White House meeting because the McDonnell case prohibits that. I'd like to make one other point because the House managers today have brought up a lot. There have been a lot of questions again and again about the subpoena power and were their subpoenas actually valid and how it's going to destroy oversight if the president's arguments are accepted. I just want to point something out. The subpoenas that were issued purported to have been issued not under oversight authority, but pursuant to, every letter that came out said, pursuant to the House's impeachment inquiry. They purported to be exercising the authority of impeachment, and that makes a difference because one of the House managers mentioned this. Legislative oversight, the authority to inquire into information for legislative purposes, has to actually relate to something that legislation could be passed on. There's certain constraints on what information could be sought. Slightly different if you're going under the impeachment power, because then you can investigate into specific past facts more readily, because that's relevant to an impeachment inquiry that might not be for legislative purposes. They purported to be using the impeachment authority. They didn't have that authorization because the Speaker's press conference did not validly give them that authorization. We pointed out that the subpoenas were invalid. They did nothing to try to cure that deficiency. They didn't reissue the subpoenas, they didn't have the vote and reissue them or anything. And to say now that all of oversight will be destroyed forever if you accept the president's arguments is totally false. It's totally misleading because they weren't purporting to do just regular oversight. And as we've pointed out several times, the October 8th letter, that the White House counsel sent to Chairman Schiff and others said specifically, if you want to return to regular oversight, we're happy to do that. As we have in the past, subject to constitutional constraints, we'll participate in the accommodations process. And it was the House Democrats that didn't want to take that route. So they insist on using the impeachment authority. We pointed out that they didn't have it, and they didn't seek to cure that problem. So accepting the president's position here has nothing to do with destroying oversight by Congress for all time and all circumstances. It has to do with the mistake that they made in trying to assert a particular authority that they didn't have in this case.
Question from Senator Braun and Barrasso for counsel for the president. The House managers have said the country must be saved from this president, and he does not have the best interests of the American people and their families in mind. Do you wish to respond to that claim?
While the House managers are coming before you and accusing the president of doing things, in their words, solely for personal and political gain, and claiming that he is not doing things in the best interest of the American people are telling you just the opposite. The president's approval rating, while we are sitting here in the middle of these impeachment proceedings, have hit an all-time high. A recent poll shows that the American people are the happiest they've been with the direction of the country in 15 years. Whether it's the economy, security, military preparedness, safer streets, or safer neighborhoods, they are all way up. We, the American people, are happier. And yet, the House managers tell you that the president needs to be removed because he's an immediate threat to our country. Listen to the words that they just said. We, the American people, cannot decide who should be our president because, as they tell us, and these are their words, quote, we cannot be assured that the vote will be fairly won. Do you really, really believe that? Do you really think so little of the American people? We don't. We trust the American people to decide who should be our president. Candidly, it's crazy to think otherwise. So what's really going on? What's really going on is that he's a threat to them, and he's an immediate legitimate threat to them, an immediate legitimate threat to their candidates because the election is only 8 months away. Let's talk about some of the things the president has done. We've replaced NAFTA with the historic MCA. We've killed the terrorists al-Baghdadi and Soleimani. We secured $738 billion to rebuild the military. There are more than 7 million jobs created since the election. Illegal border crossings are down 78% since May, and 100 miles of the wall have been built. The unemployment rate is the lowest in 50 years. More Americans, nearly 160 million, are employed than ever before. The African American unemployment, the Hispanic American unemployment, the Asian American unemployment has the lowest rate ever recorded. Women's unemployment recently hit the lowest rate in more than 65 years. Every U.S. metropolitan area saw per capita growth in 2018. Real wages have gone up by 8% for the low-income workers. Real median household income is now the highest level ever recorded. 40 million fewer people live in households receiving government assistance. We signed the biggest package of tax cuts and reforms in history. Since then, over $1 trillion has poured back into the U.S. 650,000 single mothers have been lifted out of poverty. We secured the largest ever increase for child care funding, helping more than 800,000 low-income families access high-quality affordable care. We passed, as Manager Jeffries will recall, bipartisan criminal justice reform. Prescription drugs have seen the largest price decrease in over half a century. Drug overdose deaths fell nationwide in 2018 for the first time in nearly 30 years. A Gallup poll from just 3 days ago says that President Trump's upbeat view of the nation's economy, military strength, economic opportunity, and overall quality of life will likely resonate with Americans when he delivers the State of the Union address to Congress next week. If all that is solely, in their words, for his personal and political gain and not in the best interest of the American people, then I say, God bless him. Keep doing it. Keep doing it. Keep doing it. Maybe if the House managers stop opposing him and harassing everyone associated with him with the constant letters and the constant investigations, maybe we can even get more done. Let's try something different now. Join us. Join us. One nation, one people. Enough is enough. Stop all of this.
The question from Senator Graham and the other senators is for the counsel for the president. Assuming for argument's sake that Bolton were to testify in the light most favorable to the allegations contained in the articles of impeachment, isn't it true that the allegations still would not rise to the level of an impeachable offense, and that, therefore, for this and other reasons, his testimony would add nothing to this case?
Let me start by just making very clear that there was no quid pro quo, and there is no evidence to show that. There was not that sort of linkage that the House managers have suggested. But let me answer the question directly, which I understand to be, assuming for the sake of argument that Ambassador Bolton would come and testify the way the New York Times article alleges, the way his book describes the conversation, then it is correct that even if that happened, even if he gave that testimony, the articles of impeachment still wouldn't rise to an impeachable offense. And that's for at least two reasons. Let me explain that. The first is, on their face, the articles of impeachment, as they've been laid out by the House managers, even if you take everything that's alleged in them, they don't, as a matter of law, rise to the level of an impeachable offense. Because even the House managers haven't characterized them as involving a crime. So that's one level of the answer, that an impeachable offense would require a crime. Even going beyond that to a second level, the theory of abuse of power that they've alleged, put aside whether or not it's a crime, the theory of abuse of power that they have asserted is not something that conforms with the constitutional standard of high crimes and misdemeanors. It depends entirely on subjective intent, and it is subjective intent alone. And as Professor Dershowitz explained, and as I've explained, and I don't mean in the more radical portion of his explanation of his theory, I mean just in terms of what is high crimes and misdemeanors. He explained that something that is based entirely on subjective intent is equivalent to maladministration. It's equivalent to exactly the standard that the framers rejected because it's completely malleable. It doesn't define any real standard for an offense. It allows you to take any conduct that on its face is perfectly permissible, and on the basis of your projection of a disagreement with that conduct, a disagreement with the reasons for it, to attribute a bad motive, to try to say there's a bad subjective motive for doing that and we'll make it impeachable. That doesn't conform to the constitutional standard. So at the common law, they would call the reaction to a charge like this a demur. You demur and simply say, even if everything you say is true, that's not an impeachable offense under the law. And that is an appropriate response here. Even if everything you allege is true, even if John Bolton would say it's true, that is not an impeachable offense under the constitutional standard, because the way you've tried to define the constitutional standard, this theory of abuse of power, is far too malleable. And it goes purely to subjective intent, and it can't be relied upon. Then the third level of my answer is this. We've demonstrated that there is a legitimate public policy interest in both of the matters that were raised on that telephone call, the 2016 election interference and the Biden-Burisma affair. Because there is a legitimate public policy interest in both of those issues, even if it were true that there was some connection, even if it were true that the president had suggested or thought that, well, maybe I should hold up this aid until they do something, that's perfectly permissible where there is that legitimate public policy interest. It's just the same as if there is an investigation going on, the president wants a foreign country to provide some assistance. It's a legitimate foreign policy interest to get that assistance. It's legitimate to use the levers of foreign policy to secure that assistance. So because there is a legitimate public policy interest in both of those issues, and I think we've demonstrated that clearly, it would be permissible for there to be that linkage. But again, I'll close with where I began, which is there was no such linkage here. I just want to make that clear. But taking for the sake of argument the question as phrased, even if Ambassador Bolton would testify to that, even if you assumed it would be true, there is no impeachable offense stated in the articles of impeachment.